Good evening, everyone. I'm James Norton, and it is my pleasure as Executive Editor to welcome you all to the launch of issue 38.2 of the University of New South Wales Law Journal. This issue features 7 articles devoted to the theme of rethinking detention in Australia, and a further 6 on diverse, important legal issues of today. I first of all acknowledge the traditional custodians of the land, the Gadigal people of the Eora Nation, and pay my respects to their elders, past and present. I would like to extend a special welcome to a number of our distinguished guests here tonight. Our keynote speaker for the evening, Mr. Julian Burnside, Officer of the Order of Australia. Tom Hynum, Alan's partner and practice group leader of the Banking and Finance Group. 3 of the issue's authors, Professor Samantha Hepburn of Deakin University, Dr. Svetlana Tolkina from UNSW, and Ms. Felicity Bell of the University of Wollongong. And finally, the board of the UNSW Law Journal and its alumni. The UNSW Law Journal has this year marked 40 years since its founding as the law school's flagship publication, and we are thrilled with its continuing expansion. 2015 marks our shift to 4 issues per year, made possible by the overwhelming number of high-quality submissions. Under the journal's unique publication structure, articles on topics right across the legal spectrum are published in a general component of each issue, and a collection of perspectives on a single topic of high contemporary importance forms a thematic component of each issue. Under this structure, the journal is at once able to offer commentary on a wide range of subjects in the Australian legal environment and stimulate discussion and debate in an area deserving of particular attention. Since 2013, the journal has also published outstanding student articles online in the UNSW Law Journal Student Series, hosted on the Social Sciences Research Network. The student series consists of the best works produced by undergraduate law and Juris Doctor students at UNSW and offers a stepping stone into the world of academic publication. We as a journal are very proud to be entirely student-run, as we have been from our inception. That a student-run journal is regarded as one of the best peer-reviewed legal reviews in the country is a testament to decades of hard-working students, and it is an honour to continue this tradition. On the editorial board's behalf, I would like to express my gratitude to Premier sponsor Allens, our hosts this evening. Allens, and its former incarnations, dating right back to Allen and Hemsley, have been continuous supporters of the journal since its founding 4 decades ago. The journal would not be where it is today without their generous support. I thank Tom Hynum for representing the firm here this evening, and Lisa Miller, graduate resourcing consultant, for her significant effort in bringing tonight together. I would also like to thank our 2 other premier sponsors, Herbert Smith Freehills and Kingwood Mallisons, for their support of the journal. We are also appreciative of the continued guidance and advice of the Law Journal's faculty advisors, Associate Professors Lyria Bennett-Moses and Michael Handler, and the Dean of the UNSW Law School, Professor David Dixon. As a student-run publication, the journal is nothing without its board. This issue is the result of the toil of 29 voluntary board members who have put in significant time and effort to bring this issue to print. Thank you to each and every one of you. Finally, I save my last thanks for Anna Rienstra, the editor of this issue. Anna has guided this issue from its beginnings as a call for submissions 1 year ago through the stages of peer review, editing, and printing. Those short descriptors of stages cannot, however, do justice to the amount of work Anna has put in, and are even less apt to describe the skill and dedication with which she has carried out her role. I hope too you have enjoyed your time as issue editor, Anna, the surprises of which are never ending. These have ranged from what one might term the benign to the ridiculous, finding last-minute typos, to finding the name of a certain Sir Owen Dixon on tonight's RSVP form. Anna, although I'm still yet to cite the Chief Justice here tonight, but I nonetheless congratulate you on a tremendous issue and on your professionalism and hard work throughout. With that, I would now like to invite Tom Hynum to speak on behalf of Allens. Tom is a partner and practice group leader of the Banking and Finance Group. He began his career in the UK and has been at Allens since the year 2000. Tom specialises in acquisition finance and structured finance with a particular expertise in derivatives. He acts for the investment banking arms of the Big 4 Australian banks and for offshore investment banks with Australian operations. Tom is heavily involved in the summer clerkship and graduate program at Allens and will no doubt have the pleasure of meeting some of you this year. Thank you, Tom.
Well, thanks very much, James. First, I'd just like to welcome everyone to Alan's this evening. It's great to see such a fantastic turnout here. Alan's, I think James might have mentioned, we're a founding sponsor of the UNSW Law Journal, and we enjoy a very close relationship with the University of New South Wales. As James mentioned, I'm quite heavily involved in the graduate recruitment committee, and I can see around me a number of students who've come through UNSW and are now employees at Alan's. Every year we get a fantastic cohort of students coming through UNSW, and we'd like to see more coming through this year in the summer clerkship applications. That's my one plug for Alan's here now. We are honoured to have Mr. Julian Burnside here to deliver tonight's keynote address. Mr. Burnside is a distinguished barrister, human rights advocate, and author. He was the senior counsel to Liberty Victoria in the Tampa litigation. He was the winner of the prestigious 2014 Sydney Peace Prize for his advocacy for human rights, and in particular asylum seeker rights. Like Alan's, he acts pro bono on many human rights cases. Now, tonight's topic is Rethinking Detention in Australia, on which he is ideally positioned to discuss. I'll now pass on to Anna Rienstra, who will introduce tonight's issue.
Thank you, Tom. Distinguished guests, ladies and gentlemen, it is with great pleasure that I welcome you to the launch of the University of New South Wales Law Journal, issue 38-2. As James has mentioned, each issue of the journal comprises two equally important parts, a general and a thematic component. The general component of this issue contains 6 outstanding articles addressing contemporary issues in Australian legal scholarship. The articles explore the family court's approach to the authorisation of hormone therapy for children with gender dysphoria, the appropriateness of current legislative regimes for the confiscation of proceeds of crime, the role and behaviour of lawyers who represent clients in mediations, the limitations of a market-based approach to the regulation of farm animal welfare, the Australian Code of Banking Practice and its relationship with consumer protection standards, and the constructional choices in statutory interpretation relating to native title extinguishment. The thematic component of this issue consists of 7 articles addressing detention in Australia that is imposed for purposes other than criminal punishment. Any kind of imprisonment has severe consequences for individual rights. Detention imposed for purposes other than criminal punishment raises the question of whether these consequences are justified. In addition, it challenges key legal principles such as fair process, the separation of powers, and the rule of law. The legal regimes for detention in Australia are numerous and varied. Asylum seekers and other non-citizens without visas are subject to mandatory immigration detention. Individuals can be detained for up to 14 days to prevent an imminent terrorist attack or to preserve evidence relating to a terrorist attack. The continuing detention of sex offenders and other high-risk offenders is permitted in a range of circumstances. Mentally ill persons can be detained if they are unfit to be tried, if they are acquitted on the grounds of insanity or automatism, or following a civil commitment. In criminal justice settings, detention is utilised for questioning and remand. In all of these circumstances, it is argued that restricting the liberty of the person detained is justified by the need for some form of community protection. In this context, the thematic component aims to generate insights into the appropriateness of such forms of detention and the use of detention in the Australian legal system more broadly. At the intersection of public law and criminal law, the thematic component also juxtaposes perspectives on detention that may not have otherwise been considered together. This issue, which I'm thrilled to see here in print, has come to fruition through the dedication of many people, to whom I am deeply grateful. First, I would like to thank Dr. Nicola McGarity, Dr. Vicky Sentis, and Dr. Paul Kildare from the UNSW Faculty of Law for their assistance with the development of the thematic topic. Their direction and encouragement have been invaluable, and the thematic component has benefited greatly from their expertise. I would like to thank Professor David Dixon, Dean of the UNSW Faculty of Law, for his ongoing encouragement. I would like to thank Associate Professors Lyria Bennett-Moses and Michael Handler, the journal's faculty advisors, for their wise counsel throughout the publication process. I would like to acknowledge the anonymous peer reviewers for their considered assessments of the articles submitted to this issue. Without their help, a student-run journal could not ensure the publication of high-quality submissions and provide each submitting author with constructive feedback. Special thanks go to the members of the Executive Committee for their unwavering support, good humour, and friendship. It has been a pleasure to work with these people, and their contribution to the issue has been enormous. Thanks must also go to the members of the editorial board, who have edited each article with diligence and tenacity. I am extremely grateful to Dr. Michael Grucock from the UNSW Faculty of Law for writing the foreword to the thematic component. I would also like to extend my gratitude to our premier sponsors, Allens, Herbert Smith Freehills, and King & Wood Mallesons. Their generous support of the journal is greatly appreciated. Finally, I would like to thank the authors for their wide-ranging and insightful contributions to the issue. It has been a privilege to prepare their articles for publication. I would now like to introduce Mr. Julian Burnside, Officer of the Order of Australia, who will deliver the keynote address tonight. The UNSW Faculty of Law was honoured by Mr. Burnside earlier this year when he delivered the annual Hal Wooten Lecture, reflecting on the role of chance in his career and in the lives of asylum seekers. We sincerely thank Mr. Burnside for his special effort to attend the launch. It is now my pleasure to welcome Mr. Burnside.
Thanks very much, Anna. I'm very glad to have been able to come tonight. There was a bit of toing and froing about whether I'd actually be able to do it tonight. And then she threatened me that if I couldn't come and launch it, I'd have to write the foreword. So I thought it'd probably be easier to come and talk. I embarked on this with some trepidation because I've long since lost my love affair with academic writing. And I've tended to regard academic legal writing as the work of people sitting on the cart of history looking backwards. But I was enormously impressed at the quality of the articles in this journal. They were fantastic. Now, I know you think that I'm only meant to talk about detention because people only ever know me as doing stuff to do with refugees. But I was very interested in the article on mediation. And I don't regard myself as an ADR zealot, by the way, just so the authors know that. But I thought, and I think mediation actually is extremely interesting. I suppose I'm an adversarial person. I like the contest of things in court, but mediation is a very important element of the whole justice system. I hate appearing in a mediation as a barrister because it's seriously boring. But being a mediator is actually a very creative role, and you don't need to be an ADR zealot to see that. ADR gives a remarkable possibility of enlarging the pie that the parties are fighting over and giving each of them rather more than they might have expected, and certainly more than they would have got if they'd gone to judgment. Anyway, so there's the unpaid plug for ADR. And I do apologise for Sam Hepburn, who I was talking to before. Statutory interpretation and native title extinguishment is frankly far too complex for me to make any useful observations about. But I am interested in the idea of detention. And detention falls into two categories, and they're superbly dealt with in the articles in this volume of the journal. There's the mandatory detention of asylum seekers, which, bear in mind very clearly, it's detention of people who've committed no offence. And then there is the detention of people in case they're about to commit an offence, or because they have been convicted of committing an offence and there's a concern that they might commit another one if they're let out at the end of their sentence. I think all of those forms of detention is offensive, because if the system is to be a true justice system, it's desirable that the liberty of people should not be denied except for extremely good reasons shown. I was very struck by two essays in particular on this subject, an article by Joyce Cheer and an article by Patrick Emerton and Maria O'Sullivan. And in each of those articles, for those of you who are concerned about this area, there is the most marvellous synthesis of what the High Court has done from Lim's case through Al-Khatib to S4. I have to say I was enormously impressed to see the way those authors dealt with that gradual shift of position of the High Court to a position where, and I was discussing this with Stephen Blanks a few minutes before, maybe there's room for further developments of the law so that people innocent of any offence may not be held for sustained times. It's a very depressing thing to think that in our justice system, many aspects of which are a source of great pride, in our present justice system, people who are innocent of any offence can be detained, if necessary, for the rest of their lives in conditions which are inclined to drive people insane. Now, you know, there's something wrong with the system that does that. Al-Khatib is probably the key case, and I think the High Court is still recovering its ground from the Al-Khatib decision. For those of you who haven't read the journal and aren't familiar with Al-Khatib was a boat person who came here. Back then, the Migration Act says that if you're a non-citizen and you don't have a visa, then you must be detained and remain in detention until you get a visa or until you're removed from the country. That was the mandatory detention system. It was later supplemented with the Pacific Solution. Now, Al-Khatib was held in, I think he was in Woomera, and he was initially rejected for his asylum claim, and so he was refused a visa. But he found detention so unbearable that he wasn't prepared to prolong it by appealing. He probably would have succeeded. He wasn't prepared to prolong his detention, and so he said to the government, please just remove me from Australia, I'll sign anything you want. But he couldn't be removed because he's stateless. There was nowhere to send him. And so the Howard government argued all the way to the High Court that that man, innocent of any offence, not suspected of being a risk to anyone, could remain in detention for the rest of his life. Think about that. By a majority of 4-3, the High Court said that's what the Act means, and with that meaning it's constitutionally valid. I think the Al-Khatib decision of the High Court will in later generations be regarded as the Dred Scott decision, or equivalent to the Dred Scott decision of the US Supreme Court in, 1859 or thereabouts. It's one of those decisions which is frankly embarrassing to read. The idea that in a civilised nation an innocent human being can be locked up forever is alarming. On the other hand, in the curious practical way that Australian politics seems to have, I don't know how many people know the practical consequences of this for Al-Khatib. Al-Khatib's case was slotted into the High Court list in place of the Al-Masri decision. Al-Masri was a similar circumstance. Al-Masri was decided by Ron Merkel at first instance, who said, no, he can't be detained forever, he's got to be released. That went on appeal to the full federal court, and the full federal court agreed with Merkel, and Al-Masri was released into the community. The case was on its way up to the High Court because the Howard government was concerned to make sure that it could jail people for life. By chance, as these things happen, some country was prepared to take Al-Masri. So he was removed from the country, and Al-Khatib was slotted into his position in the High Court list. Now, because of the Al-Masri decision, Al-Khatib had already been released. He'd been released into the community on the basis of the Al-Masri decision. He was still free in the community when the case went to the High Court in November 2003. And he was still in the community in early 2004 when the decision was handed down. And to her credit, Amanda Vanstone, about whom I don't have a lot of good things to say, but to her credit, she worked out some dodgy sort of visa that she could give to Al-Khatib so that he didn't have to go back into detention, notwithstanding what 4 judges of the High Court had said. And subsequently, Al-Khatib obtained Australian citizenship and he sent me a copy of his certificate of citizenship, which is a very proud possession, obtained in very unusual circumstances when you think it through. Now, there are other essays in the journal that deal with maritime detention, which of course came to the fore pretty powerfully with the 157 Sri Lankan asylum seekers. And then a very interesting article about detention on Nauru, written by Azadeh Dastiari. And I was interested in that because it leans very heavily on a case which I think I argued in the Supreme Court of Nauru. It makes the point that, of course, the Nauruan Constitution has got an embedded Bill of Rights, a constitutional Bill of Rights, which I think we drafted for them, which prohibits, amongst other things, arbitrary detention. And that causes problems when they're being used as a warehouse for refugees we don't want. Dastiari's article makes the point that they have recently introduced in Nauru a form of occasional day release of some selected detainees, so that it can't be said with the confidence that's necessary to get to Nauru and go to court there, that they are being detained. Unfortunately, because Anna's been so diligent in getting this to press, Dastiari's essay doesn't include reference to an event that happened last Sunday on Nauru. A woman, 23 years old, an asylum seeker, who's been detained there now for quite a long time, was one of the people who was allowed day release. She was found naked, raped on a roadway in Nauru. The police arrested her and put her in the cells at the police station. They did not get medical help for her. They put her in the police station until she could be returned into the detention centre. That's the way in which we have managed to persuade Nauru to deal with its constitutional Bill of Rights and the refugees that we want to get rid of. It's also interesting that, and this is no criticism of the author, that he was not able to include in his essay any reference to the rather curious mental state of the people who are operating the detention centres on Australia's behalf in Nauru. Transfield, who have the primary contract, representatives of Transfield, you'll recall, were called to the Senate inquiry earlier this week, and they couldn't remember anything much. They don't seem to know what they're doing. I can't work out, and I apologise if there's anyone in the room here from Transfield or acting for Transfield, but it seems to me there's only a few possible explanations for their apparent widespread ignorance and their willingness to take everything on notice. One is that they're fools, and that's possible. Another is that they're rogues, and that's also possible. And the third is that their standards have been utterly suborned by a $1.2 billion contract, which they're keen not to lose. Because I suspect that if the public knew clearly what is being done in offshore detention of innocent human beings in our name, the public, I hope, would be upset. I was recently visited in Chambers by a guy who's a doctor. He has spent most of his professional life working in the prison system in Australia, in civilian prisons. But he spent last year, 2014, working in the detention system in Manus Island, which is also run by Transfield. And he came to me because he was concerned about what was going on there after having spent a year there, especially having witnessed the aftermath of the murder of Reza Barati in detention and so on. And he said three things that really struck me. He said when he arrived at Manus Island, at the compound, his instinctive response was, this is what Auschwitz must have been like. This is a facility being run by us at taxpayer expense. His second reaction, it's 100 times worse than any civilian prison he's worked in. And his third was, it is being conducted on a basis which is essentially explicit, that we need to break the spirit of the asylum seekers so they will not pursue their claim for protection and will instead prefer to be returned to the country from which they have fled. Which brings to mind an observation made to me by a number of different asylum seekers in detention at a number of different times, which is, in my country they kill you quickly, in Australia they kill you slowly. I mention these things because our detention system, as it's operated now, is clearly being operated for the purpose of playing out a political objective. You may remember that the Pacific solution, in its current incarnation, is a result of an apparent desire to avoid the possibility of people drowning in their attempt to escape persecution. We don't mind if they die somewhere else. We don't mind if they die at the hands of their persecutors. We don't mind if they travel in some different direction and die out of sight. What we're concerned about is them dying in circumstances where we can see it on national television. The awful crashing of a boat off the shores of Christmas Island provided the perfect political opportunity for politicians to say, we want to stop the drownings. That morphed into, we want to stop the boats. And that in turn became, we want to stop the boats from arriving. We know that boats are still leaving. We don't know how many people are drowning because we're not allowed to. That's an operational matter. But we do know that the boats have more or less stopped arriving in Australia, and that's the ultimate political objective. The irony is that in order to stop the boats, in order ostensibly to prevent people from drowning, we punish them if they don't drown. I'm not sure of the logic of that, but the fact is that our policy involves punishing people who don't drown in order to save others from drowning, because we'd rather they die some other way, some other place. There's another form of detention which is very important to bear in mind, and which is the subject of other essays in this volume, and that is detention of people who might commit a terrorist offence, or, as Stephen Blanks reminded me, as a result of a bit of political manoeuvring earlier this week, people who have returned from fighting with Islamic State may be stripped of their citizenship. If they're stripped of their citizenship and they don't have citizenship of any other country, they become non-citizens who cannot be removed from Australia. And that means they will be subject to being detained for the rest of their lives without charge, without trial. If that's the political objective, it should fill all of us with a sense of fear that we have a government which is willing to embark on that sort of project. The idea that we would deliberately jail Australians for the rest of their lives without charge, without trial, because of something they've done which is not a criminal offence, is so antithetical to Australian values that all of us, no matter what your politics, all of us should try to resist it. Can I then turn to one final observation? Two final observations. The first is, reading the essays in this volume of the journal brings you face to face with a very uncomfortable fact that we seem in some very important ways to have lost our sense of decency. The sense of decency which I think has always characterised Australia as being people who really genuinely believe in the idea of a fair go, people who genuinely believe in decent treatment of others. That seems to be getting lost in recent political developments. And in saying that, I'm blaming both major parties, not the present government alone, but both major parties, who seem to have collaborated in policies and legislation which inevitably have dreadful consequences for the people who are caught up in them. And as these essays make very clear, the scope for legal remedies seems to be very limited, because as long as the Parliament can nail down the legislation tightly enough, it then has power to jail people indefinitely without charge, and that's something which should trouble all of us. And incidentally, the idea of jailing people ahead of time just in case they might be about to commit a terrorist offence should lead us to wonder, why would we do that? Why would we do that? How many terrorist deaths have there been in Australia in the last century? I think about 5. The largest number of deaths in a terrorist incident in Australia was in December 1854, when 27 people died at the Eureka Uprising in Victoria. That's one of the iconic historical episodes in Australia's history, so we're not allowed to criticise it, but it was a terrorist event. 27 people died. It was a record for terrorist deaths in Australia. But every year, about 60 or 70 people die as victims of domestic violence. Why is it we are so obsessed about terrorism, which claims very few lives in Australia, and yet apparently pretty relaxed about domestic violence, which claims a very large number of lives? If we're going to concentrate on law enforcement, let's concentrate on the real problems, not the imagined problems. But in circumstances where the politics of fear govern the day, then I suppose a concentration on terrorism is not surprising. The second final thing I'm going to say is this. The essays in this volume bring into focus something which I've been concerned about for a while, and it's this. It is just possible that 50 years from now, the idea of thinking about human rights will have disappeared from our mental landscape. Some of you will recall that even into the 1920s, the idea of eugenics was still respectable and interesting, not universally acclaimed, but it was still respectable enough for it to have been embraced by Oliver Wendell Holmes in the US Supreme Court. The Second World War gave it the bad name it deserves, and it is no longer thought about. It's not that it's a matter of contest, it's just not thought about anymore. In the 1890s, spiritualism was something which a lot of many very intelligent people embraced and considered significant, and which they debated and thought about. It's not thought about anymore. It worries me to think that human rights might become one of those areas of thought which is simply rubbed off the map of intellectual consideration. Modern human rights discourse began in the wake of the Second World War, starting with the Universal Declaration of Human Rights, which was Eleanor Roosevelt's great enterprise, and then followed by all of the great international human rights conventions that we're all familiar with. But September 11, 2001 marked a seismic shift. The tide began to retreat, and there is a real concern that human rights will stop being an area which people even think about. For those of you who have the good fortune to read the essays in this volume of the journal, I hope you will at least try to keep a discussion of human rights thinking alive so that it does not slip into obscurity and be forgotten. Because if that happens, then the essential decency of this country is at great risk. Thank you very much.